The final step is to draft and execute the documents. The lease draft can be its own negotiation as you attempt to iron out the minutiae of the contract. Remember that attorneys don't decide what goes in a contract, the clients do. And in this case, that means you, the subtenant, and the landlord. Don't shortcut this process or let anyone tell you that certain sections of a contract are quote-unquote standard. Listen closely to your attorney's advice and fight hard for the things that are important. If you've struck an agreement for a lease termination, then you can expect your landlord to draft the agreement. Have your attorney do a thorough review, and when you're satisfied, you can execute the agreement and you're done. If you do a sublease, then your subtenant will expect you to draft the sublease agreement, and the landlord will draft the landlord consent form. You might not have heard of a landlord consent form, but they're required for almost any sublease. It's a separate document that is signed by all three parties, you, the subtenant, and the landlord, and your sublease isn't valid without it. Hopefully you already reviewed your current lease when you created your project timeline, but if not, make sure you do it now. There are a few important things to look for regarding landlord consent. For example, how long does a landlord have to respond after you request consent? I've seen leases that have no time frame, which technically means the landlord never has to respond and therefore can effectively kill your deal. If there is a time frame, is consent automatic when it expires? This should be the case, but check to make sure. What are the reasons the landlord can deny your sublease? In some cases, the landlord's lender may also have to approve the sublease, which might not be stated in your master lease, so make sure you inquire about that. Review the landlord consent form thoroughly with your attorney. This is a legally binding document that can have a significant impact. Some consent forms can have onerous provisions that can actually negate some of the terms that you just negotiated in the sublease. Be aware that there is no such thing as a standard form. If your landlord gives you their form and says, "This is what all of our tenants sign," you should ignore that comment completely and do a thorough review. If you do find issues, then don't hesitate to push back. Sometimes this is hard because you may be feeling anxious about getting the deal done, but if there's a problem, then you should attempt to get it changed. In order to speed up the process, I recommend that you circulate documents before they are signed. Technically, you don't have to show your landlord the sublease agreement until it has been executed, but in my opinion, you should let them preview the final draft before everyone signs. The reason is that it's possible the landlord will have some changes, and if so, it's frustrating to make those changes because you and your subtenant will have to sign everything again. Similarly, you don't need to show your subtenant the landlord consent form until after the sublease is signed, but I recommend sending them a draft after you're done editing, but before you've signed it. It's possible your subtenant will have changes, and it's better to work those out ahead of time. This concludes the course entitled How to Dispose of Leased Office Space. I truly hope that you found it informative, and feel free to reach out to me if you have any questions.